Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II.
Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II, Principal at Carter Arnett PLLC in Dallas. Bob is a seasoned trial attorney with more than 35 years of experience handling complex business, intellectual property, and real estate disputes in Texas and federal courts nationwide. I'm Leanne Lyon, and today we're talking about what happens when business agreements break down and end up in court. This is When Deals Unravel, common contract disputes that end up in court. Bob, since this is our first episode, let's start with you. How did your career in commercial litigation begin, and what kind of cases have shaped the way you practice today?
Well, I guess to go back to how I got in, how I became a lawyer, or what got me interested in the law, I graduated from Rice University and went into the Marine Corps, where I was an infantry officer. And in that role, I handled a lot of summary courts martial. And then I became the battalion legal officer, and I interfaced with the lawyers who were prosecuting our really bad guys, and really became interested in the law at that point. And when I decided I wasn't going to make the Marine Corps a career, I decided to, if those guys could do it, I figured I could do what they were doing. And so, I went off active duty, went to law school, and then, went back to Hawaii, where I had been stationed. But I went back and practiced there for 7-8 years. And I was with a big firm, but in a small off-island office. So we were on the Big Island, and there were, two of us to start with. It got as big as 6 attorneys while I was there, but we handled a wide variety of things. And so I started gravitating more towards the commercial cases. Real estate in Hawaii is obviously very expensive, and can tolerate the big dollar case disputes. So I gravitated towards that and have been involved in commercial litigation ever since.
So when contract disputes land in court, what are the main issues that tend to decide the outcome?
Well, the main issues are the contract language. The courts are supposed to apply contracts as they're written, unless somebody argues that there's ambiguity or uncertainty as to the meaning of the contract. So what's actually written in the contract tends to be a primary factor in determining how the case is going to turn out.
So speaking of ambiguity, are there things that tend to cause contracts that seem clear at the beginning at signing to break down later on?
I think probably the biggest thing is, when people aren't careful in terms of drafting their contracts, in making sure that the contract says what they believe the deal is. I run into the situation over and over again where, the argument is, well, yeah, the contract says that, but really the deal was this. Well, I'm sorry. In most cases, if that's what the contract says, that's what the contract says. And another thing is just, care in drafting. Lawyers tend to, when writing contracts, have very long sentences in paragraphs with lots of dependent clauses and modifying clauses. And, those can be subject to differing interpretations. Does this modifying clause modify everything that came before, or does it only modify what, immediately preceded it in the sentence? Particularly when you've got a sentence that's like 25 lines long. If people would focus on trying to be simple and direct and clear in their language, and making sure that what the contract says is what the deal actually is.
Wow. I'm just stunned. 25 lines long. That's amazing. I hope you don't run into that too often.
Well, one of the So for, transactional lawyers, who are the lawyers that basically write contracts and write leases, tend to have templates. They have forms that they've used in the past. And so a lot of that stuff just gets carried over from one deal to the next. And, really it would behoove you to really think carefully about whether you really need that paragraph or that section, or if it's drafted appropriately for the current deal. So, that's just, an observation from, because I don't typically write leases. I go to court when there's a dispute about a lease, or when there's a dispute about a contract, and you've gotten to the point of litigation having started. And then you're stuck with what the contract says, for the most part. And, I, often have suggestions back to clients about how to avoid some of these problems in the future.
So, that in mind, do surrounding circumstances ever matter?
Sometimes, generally speaking, the contract is interpreted, if it's unambiguous, the court will interpret it as a matter of law. Now, there's a bunch of, principles of interpretation or canons of interpretation. For example, every phrase, every word in a contract is supposed to have meaning. You shouldn't interpret a contract so that, one phrase just doesn't mean anything or is superfluous. A contract should be interpreted, a contract provision should be interpreted, in the context of the whole contract. And contract provision should not be interpreted to lead to absurd results. But for the most part, the courts are going to look at the contract. If there is some ambiguity, then the courts can look at surrounding circumstances. And in that case, probably one of the best, kinds of evidence is the prior drafts. You see this, where the parties have exchanged drafts back and forth for, weeks or months before they arrive at, the deal. And if somebody's claiming that something means something that was clear in an earlier version and then got struck out, that's pretty good evidence that that was not the intent of the parties at the time they got to the final contract. So, yeah, surrounding circumstances can matter. But usually, even though the lawyers disagree about the meaning, both sides will agree that the contract is unambiguous and means what it says and what they say it says.
What they say it says. Got it. And the earlier contracts are probably going back and forth via email. Do day-to-day communications in email play a part in proving or disproving a breach of contract?
Well, sure. So when you're interpreting a contract, generally speaking, you look to the language of the contract and not prior negotiations or communications. But, when it gets to proving breach, then you're talking about the conduct that occurred after the contract became effective. And so, yeah, you do look at that in terms of, because there can be issues of waiver. Did somebody acquiesce in what the other side was doing or how they were treating things? Were there, modifications to the contract that can happen by virtue of, email agreements or exchanges? So, yeah, that all matters in terms of proving a breach.
Perfect. Well, so if a business is, obviously interested in avoiding litigation, what steps during contract drafting makes the biggest difference later if a dispute arises anyway?
Again, it's, just care in drafting and making sure that your language is as simple and direct and correct as you can make it. And, in particular, because I've done a lot of construction litigation, and a lot of construction companies, both general contractors, owners, subcontractors, use form contracts that are promulgated by either the American Institute of Architects or the General Contractors Association. And, that's a pretty complete contract, but they've got, some plugins and selections, and then you can make changes to it. When companies do that in-house without having a lawyer look at it. Oftentimes they, frankly, they mess it up. They put in things that don't make sense, um, because there are boxes there to be checked, and they have somebody check the box and, you know, don't give considerable thought to it. The other thing is, um, as you are performing under the contract, pay attention to what the contract says. A lot of times it's pretty apparent that what happened was contract gets signed, both sides stick it in a file drawer somewhere and don't break it out again until they're ready to go to court over some dispute. So, you need to pay attention to what your contract says, because there's notice provisions, there's, remedies set forth in there that have to be followed. And if you don't follow them, you may find yourself out of court.
Got it. And so when those settlement talks do begin, what factors usually determine whether a case resolves early or actually ends up going all the way to trial?
Well, number one, the clarity of the contract. Contracts can be decided, the meaning of the contract can be decided by the court as a matter of law. And so contract disputes can be, more so than, say, a personal injury action, susceptible of summary judgment, meaning you can have, the judge can decide it without the need to have a trial, because, the facts, such as, party A was supposed to pay party B $1 million on completion of this, and it didn't get paid. That is pretty cut and dried. And, party A has some excuse based on how they're interpreting the contract or how they want to interpret the contract. Well, the courts can, decide that as a matter of law. So, what the contract says is very, very important. I guess the other thing is the reasonableness of the parties involved. In both real estate litigation and construction litigation, you tend to have some very hard-headed people on both sides, which makes it hard to arrive at a compromise until you get to court and have the case partially or completely decided by a judge or a jury. So the reasonableness of the parties in trying to get to a resolution is important.
I have to believe that's absolutely true. Can you share an example, without names, of course, of a contract case that illustrates how a seemingly small clause can change the entire result?
Yeah, well, there's one that comes to mind, and so this was actually a settlement agreement and a release, and there was a long, long sentence describing the claims being released, and there was one clause that had a beginning parenthesis, but there was no ending parenthesis. And so the fight was, where does the ending parenthesis belong? Does it belong up here, which completely changed the meaning of it, or does it belong down here, which makes the scope of the release much broader? So that one punctuation matter, was what led to the dispute and ultimately got the case determined.
That's amazing. Not just a small clause, but a small character. That's amazing.
Yeah.
Well, finally, as we wrap up this first episode, what is a key takeaway that you'd want business owners and in-house counsel to remember about managing contract risk before it reaches a courtroom?
Well, as I said before, when you're drafting the contract, take care. I know transactional lawyers, many of them are very careful, but some smaller companies don't have in-house counsel to review their contracts. They have a contract administrative person who does it, but you need to pay attention to what's in the contract and how it's written, and to try and make it as clear and as hopefully simple, and that it accurately reflects the deal that you think you've made. And then, as contract performance starts, pay attention to what the contract says. There are steps that are required to preserve your rights and remedies. And, oftentimes if you want to terminate the contract, there are steps that you have to take, notice and opportunity to cure things. So pay attention to the contract as performance unfolds. And then finally, if you do get into a dispute and there is issues about, who owes who money, then try your best to reach a reasonable business solution before you go to court, because litigation is expensive, and oftentimes in these kind of cases, particularly real estate cases, even if you win the case, you're not going to be better off financially than you were if you had cut a reasonable deal at the outset.
Good advice. And that's it for today's episode of the Texas Commercial Litigation Podcast. J. Robert Arnett II of Carter Arnett PLLC. To learn more about Bob and his firm's work in business and intellectual property litigation, visit carterarnett.com. Thanks for listening, and remember to like, subscribe, and share this show with anyone interested in how commercial cases really play out in Texas courts. Thank you, Bob.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.